Okay, good afternoon. Welcome to our webinar for Foreclosure Avoidance, Short Sales and Options for Distressed Homeowners. My name is Lenora. I'm the Communications Manager at Dream House Realty, Inc. The webinar today will be presented by Michael Gaddis, attorney and real estate broker for Dream House Realty, Inc., our full-service real estate company based in Oceanside, California. Michael, in addition to being a licensed California attorney, is a mortgage broker and real estate broker with nearly a decade of experience helping individuals and families buy, sell, and save their homes. With over 100 closed short sales transactions and nearing 1,000 successful loan modifications under his belt, Michael has the in-depth knowledge and experience it takes to negotiate with lenders and banks to effectively assist homeowners with their distressed properties. This presentation will last approximately 40 minutes and will begin shortly. Take notes and jot down your questions during the presentation or type them into the chat box so Michael can answer them at the end of the presentation in the Q&A portion of the webinar. For additional information on Dream House Realty, Inc. and our successes on helping people with their real estate goals, you can visit us at www.dreamhouserealtyinc.net or call us toll-free at 888-242-2272 to set up an in-person meeting. And without further delay, I'm going to hand the reins over to Michael Gaddis.
Thank you, Lenora. Okay. Today we're going to talk about foreclosure prevention, different types of things that homeowners can do if they're facing any type of distress. The first thing I actually want to talk about are what options are available to distressed homeowners. A lot of that depends on when the homeowner realizes that they're in trouble. If they realize that they're in trouble while they're still current on their loan, they still might have a refinance option available to them. The problem with refinance for most distressed homeowners is that the loan-to-value of their house might not satisfy a refinance options, meaning that they're underwater on their house, or there's not enough equity there where they can procure a new loan. Now, if their loan is owned by Fannie Mae or Freddie Mac, they might be eligible for a HARP refinance. That's a special refinance program available to homeowners that are underwater. It used to cap the underwater LTV at 125%, but now it's possible to where it's unlimited. It just depends on if the lender who is willing to do the HARP is willing to go above and beyond the 125%. However, it comes to be that most of the time, refinance is not really a viable option for a distressed homeowner. That leaves the second type of remedy for a distressed homeowner, which is a loan modification. The third type of potential remedy for a homeowner is a special forbearance of some type. The fourth is a short sale, and the fifth is a deed in lieu of foreclosure. All of those are different types of remedies that a distressed homeowner could go to. However, there's a waterfall, so to speak, of how a distressed homeowner should go about analyzing their situation. Obviously, when you do it, the first thing you want to do is look at a refinance. If that doesn't work, you look at a loan modification or even a special forbearance. And if that doesn't work, then unfortunately they're probably going to have to look towards a short sale or a deed in lieu of foreclosure. The second thing I'd like to talk about is what loss mitigation is. All of the options, with the exception of the refinance above, are loss mitigation options available to the lender or the investor on the loan. Loss mitigation is basically making the best of a bad situation. When a distressed homeowner is late on their payments, the investor is at a risk of loss. So at that point in time, there are options available to him that would allow him to try to minimize the amount of potential losses that he might incur, and that's exactly what loss mitigation is. So let's talk about, just real quickly again, refinance and HARP refinance. As I mentioned, the loan-to-value of a person's house, meaning how much they owe versus how much their house is worth, prevents most homeowners who are in this type of a market from refinancing. That's because most lenders have gone away from 100%, well, almost all lenders have gone away from 100% LTV type loans. And since most homeowners who are in distress are above 100%, there's nobody who's willing to take on a house when the loan amount is worth more than their security. And Fannie and Freddie are the only ones under the HARP program that will go above the 100% program. So that leaves that most homeowners have to go and try to figure out if a loan modification is the best for them. A loan modification is a change to the existing terms of a person's note. What that basically means is that their existing note that they signed at the time they got their loan is going to stay in effect. A loan modification just changes certain terms to that. Now, loan modifications are not rights. A lot of homeowners think that they're entitled to receive a loan modification, but that's not necessarily true. Loan modifications are basically, as I mentioned, loss mitigation tools for the investor. They're an avenue for the investor to determine if this type of a remedy will allow them to lose less money than the other remedies. Every loan modification has 3 general tests to it. You can break it down to 3 general tests. The first test on a loan modification is the hardship test. Every borrower that applies for a loan modification has to have some sort of reason that they're applying for the loan modification. And that hardship has to meet a certain requisite, requirement in order for it to pass this test. Now, typically, homeowners that are past due 2 months or more don't usually have that difficult of a time proving hardship because there's a presumed hardship. It's homeowners that are current on their loan are less than 2 months that have a little bit more difficult time getting through this particular test. And that's because when they're 2 months or less past due, they go to the imminent default department. And the imminent default department is basically a special group that handles loans that are current are less than 2 months late. And the threshold for hardship in that particular department is very high, much higher than it is if you're more than 2 months late, where there's almost a presumption of hardship. So getting through the hardship test is the first major hurdle that anybody who's trying to obtain a loan modification has to get through. The second test that is incurred is once you get past the hardship test, I call it the financial analysis test. What a financial analysis test basically is, it's where they take the financial ability of the person of the borrower as set forth in the loan modification application documents, and they compare it to their underwriting requirements. In other words, what has the investor on the loan, the rules the investor on the loan has given the bank to be able to do a loan modification. So they take these two and they mesh them together, and it spits out a proposal. And the proposed terms could be something like a 2% on a 40-year note. It could be a principal forbearance. It could be a lot of different things. Now, just because the financial analysis test spits out a proposal doesn't necessarily mean that a homeowner is going to get the loan modification. What happens after the financial analysis test is the net present value test. And the NPV test is probably the most important of the 3 tests, because the NPV is basically a computer program that takes into consideration all sorts of data. When you fail an NPV test, they'll send you 34 inputs of different data that were used to determine whether you pass or fail this test, and there's actually even more than that. In a nutshell, what a net present value test is, it's a computer program that basically tells the investor whether they're going to lose less money by modifying you, or given the terms that you were supposed to give in step 2, or by foreclosing on you. So what they're going to do is see where their loss is over the long haul by giving you, let's say, a 2% on a 40-year note, versus foreclosing on you and reinvesting this money and getting a 3% rate of return on that. And there's a number that comes into play. If you pass the net present value test, that means that your loan modification application, the result of the financial analysis test, is worth more to the investor to modify than to foreclose. That means they've determined over the long haul it's better for them to give you a reduced interest rate and an extended amortization term versus foreclosing. If you fail the net present value test, That basically means that the investor has determined that it is not in their financial best interest to give you a 2% on a 40-year note. It is better for the investor to foreclose on you and basically take their losses now, and in the long run, they'll end up losing less money. So the NPV test is, as I mentioned, a very, very important test, and it is probably the most common reason that people fail loan modifications. What kind of tools can a lender use in modifying a loan? Well, they have several different ways that they can try to get your loan to a point that is modifiable. They can lower your interest rate. Typically, the lenders will lower their interest rates down to a floor rate of 2%. They don't typically lower any lower than that. So the first is lower the interest rate. The second is they can extend the amortization of the loan, meaning the repayment period. And that is actually one of the most helpful ways of trying to reduce homeowners' payments, because, you know, if you take a $500,000 loan and you try to make payments on a 25-year payback period, the payments will be much higher than if they could stretch that loan out to 40 years. That really helps provide a lot of homeowners payment relief, and it's a really good tool. Now, with that being said, they very rarely extend the maturity date of the loan. Now, they can, but typically they don't. So what that means is if you have a 25-year amortization period, 25-year maturity date, and they extend the amortization period to 40 years, that means your loan is still due and payable at the end of 25 years. So that results in what's called a balloon. And what that means is all the unpaid principal that you have not paid will become due and payable at that time. A lot of homeowners get scared about this proposition, but it's really nothing to be scared about. And the extension of the amortization period is really a very, very good tool that some lenders use. It's actually, some lenders are very resistant to using this particular tool, and you know it can create problems in trying to create affordable payments for homeowners. The third thing that the investors can do, the lenders, they can reduce the principal of the loan. Now, when loan modification started about 4.5 years ago or so, principal reductions were very rare. Now, they're not quite as rare as they once were, but they're still not. It's not as common as what people believe. There has been some new programs that have come into play recently that are principal reduction driven, but homeowners should not proceed with a loan modification with the presumption that they're going to get a principal reduction, because it depends on a multitude of factors that come into play whether a person is going to get a principal reduction or not. The next tool that they can use are principal forbearance or deferments. And what this means is that if they're unable to extend the amortization period, let's say they extend your amortization period to 40 years and reduce your interest rate to 2%, if they can still not achieve an affordable payment, what they'll sometimes do is they'll take money from the principal balance and put it to the end of the loan like a non-interest-bearing balloon payment. And they'll only charge you interest on what they can in order to achieve a payment within their guidelines. Now, the problem with that is, in general, it's not a problem, except if they've already reduced your principal down to the market value, like the DOJ, which we'll talk about later, does. If they have to go and start doing a principal deferment on top of that, that usually creates a failure in NPV. However, principal deferment in general is not necessarily a bad thing. I've seen it done many times where in lieu of reducing principal, they will create this principal deferment and allow someone to have a very low payment, but yet they still maintain the same principal balance. So some lenders really like to do that in lieu of the principal reduction. The one thing you have to kind of keep in mind when a homeowner is dealing with their distressed options is the fact that lenders are not your friends, and they're not there to help you or homeowners. What they are is they're there to help their investors. in the net present value test, by definition, is evidence of that. When a bank tells somebody we're here to help you, what they're really telling that person is we need to collect your documents so that we can assess you to see if you're in the best if modifying you is in the best financial interest of the investor. So that's really what they're doing. It's an assessment. They're very driven to try to obtain documents and trying to get these loan modification factors in place so that they can properly do their assessment. One is to make sure that they have satisfied their due diligence as set forth in their servicing agreements, and two, just to basically do as best an analysis as possible to determine whether that is a loan modification is a decent option for them in relation to your situation. The next thing I wanted to talk about was what is HAMP and the MHA plan. HAMP is also called the Obama plan. It has a lot of different names. It's a government plan that Fannie and Freddie loans, people who apply, who their investor is Fannie and Freddie, have to be run through the HAMP module, the Obama plan. The Obama plan is actually I like the Obama plan. It's a very good plan if you could get through all the document requirements. The problem is that it's very document heavy, and it's the way that the loan modification is processed is can be very difficult. Not all lenders participate in HAMP. It's optional for non-Fannie and Freddie. However, a lot of them do. Some of the lenders that don't, a lot of their investors don't, are PNC, for example. PNC, a lot of their investors do not participate in HAMP. Central Mortgage, I'd say about half of their investors don't participate in HAMP. So what does that mean? Well, that means if you apply for a loan modification with those particular entities, they will analyze you for a loan modification based on the investor guidelines. They call it either an investor-based modification or an in-house modification, but not a government-backed modification. The reason I like the HAMP modification is because the tools available to trying to resolve the payment within the 31% housing to income ratio that's established in the guidelines are pretty wide. I mean, they allow, as I was speaking earlier, they allow for amortization extensions, interest rate lowering. A lot of different types of tools are available. So I really like HAMP. And I really kind of get a little bit deterred when I find out that a particular investor is not participating in it. The next thing I wanted to talk about is the DOJ program, the Department of Justice program. A lot of people have read about the big settlement that occurred last year for the robo-signing. And I will tell you that the DOJ program did call for principal reductions, and I will tell you that I have seen many examples of this. So the lenders, especially Bank of America, is complying with this settlement. I haven't seen it as much from Wells Fargo or Chase, but I have definitely seen it from Bank of America. And the DOJ program is probably one of the most, I would say, one of the most searched items on my website. It's one of the things that I get the most calls about, either DOJ denials or NPV failures, whatever it might be. I will tell you that the DOJ program at Bank of America is a very good program. It does have certain tools available to it, but it also has its limitations. One of the limitations with the DOJ program is that they do not extend the amortization term. So what that means is if you've had your loan for 30 years, and if you have a 30-year loan and you've had it for 7 years, they're going to try to find a payment based on a 23-year amortization. Now, what that means is that they're crunching your principal balance into a short repayment period. So while they're cutting your principal down, they're not allowing for a lot of time for you to repay the loan. So what does that mean? That means that people who aren't underwater substantially, the resulting payment might not be exactly what they're looking for. So sometimes the DOJ program will not result in enough payment relief for a homeowner, whereas a HAMP modification would. because even if the person were to keep their same principal balance, the fact that they're extending the repayment period out to, to a much greater length allows them to get a much lower payment than they could through a principal reduction program at the DOJ. But I also will tell you that Bank of America in particular has a lot of problems with their DOJ program, and a lot of people are erroneously denied DOJ modifications based on MPV failures, or also because they're incorrectly calculating their payments and saying they're not falling within the guidelines. And I will tell you that I evaluate quite a few of these, and I would say probably 6 or 7 out of 10 of them, 60 to 70% of the ones that I review, are incorrect and need to be either appealed or readdressed. So the DOJ program, while it is great, as I said, it does have its limitations and its frustrations. The next thing I wanted to talk about is principal reductions. Fact or fantasy. Years ago, people always used to ask me about principal reductions, and as soon as they mentioned it, I try to make them stop talking, because everybody wanted a principal reduction, but lenders weren't doing it. The only lender who was really doing it from the inception was Wachovia, who became Wells Fargo. They've been always pretty good about doing principal reductions on their loans, but they were really the forerunner of it, and then gradually some other ones started jumping on board. And it is something that is done here and there now. It's much more commonplace. However, it's important to note that you cannot classify lenders as the one that are allowing for principal reductions, because lenders sometimes just service the loan. So what that means is they might not own your loan. And if they don't own your loan, they have to take rules and regulations from the investor that they're servicing it for. So the ultimate decision maker about whether your loan is eligible for a principal reduction or not is not the lender itself typically. It is the investor that owns the loan. Now that's really important, because people always come into my office and say, well, my neighbor got a principal reduction and he's a Bank of America and I'm a Bank of America, so I should get a principal reduction too. It doesn't work like that, because if the investor on the loan is different, one investor might allow for a principal reduction and another will not. Take the DOJ, for example. The DOJ program is open for the people who are eligible for principal reductions at the DOJ program at Bank of America. One, you had to have been 2 months or more late as of January 30th of 2012. If you weren't, you're not eligible. The second thing is that you have to be underwater on your house. If you're not underwater, you're not DOJ eligible. Now, I will tell you that some people have been solicited and flagged as being DOJ eligible when, in fact, they were not. They were LTV failures. They were erroneously flagged, and so what happens is these people go and try to apply for the DOJ and end up getting failure notices because of LTV denial. And so they should never have been flagged in the first place. So you had to have been late at least 2 months as of January 30th. You had to be underwater. And the third thing is that your investor, the loan you have at Bank of America has to either be owned by Bank of America or serviced by Bank of America, where the investor has given them either full delegation, meaning the investor has given them full authority to do whatever they think is best on the loan. So it's either owned by Bank of America or full delegation. If it's partial delegation or non-delegated, typically it is not DOJ eligible. So what that means is, as I said, if there are 10 people living on the street, half of them might have eligible DOJs, the other won't. And it's very difficult sometimes for people to understand that, and they'll blame Bank of America in general, but it's not Bank of America's problem, or Chase or whoever it might be. So that's about principal reductions.